Okay, so my goal today is really to introduce the field of forensic linguistics and demonstrate how linguistics can be applied to legal contexts, help answer legal questions, and ultimately further social justice. I want to demonstrate that a broad understanding of forensic linguistics is necessary to see the full applications of the field, and then I want to wrap up by kind of suggesting some ways to further develop the field, including research and awareness in Canada. So forensic linguistics, the way I'm using the term, is basically any time language is involved with the law. So I mean this in its really broadest sense. In Canada, we have different, and around the world, there's different kind of terminology used to focus on more maybe nuanced aspects of that. So we have things like legal linguistics, language and law, jury linguistics, and then what some people might call forensic linguistics separately in terms of providing expert witness consultant. But I think that these all have something in common in that they all involve applying principles and methodologies of linguistics and linguistic analyses to forensic and legal data. So I think we should consider all of these together and kind of how they work together. So I like to break things down a little separately, looking at things like the language of the law, legal discourse, language crimes, and language evidence. So I'm going to go through some of these, but I think it's important to think about how these are not mutually exclusive and they kind of all can have important implications for each other. So when I'm talking about the language of the law, I'm talking more about a legal register, so a specific way of using language in specific contexts. So this is often referred to as legalese, and we find it in like legislation, police cautions, judicial decisions, things like that, where it's typically written by a legal actor of some sort. And I think importantly for us to think about is who the audience of that is and who should be able to read that and understand that. And if there's a connection between legal language and a more ordinary language that more everyday people are familiar with. So we would characterize some aspects of legalese or legal register with things like long, complex sentences, very technical terms. In English, we have like borrowings from Latin and French, pronominal adverbs, all these types of language use that might not make it very comprehensible to an everyday person. In Canada, I think the context is pretty unique when we're talking about the language of the law because we have a bijural system and that we have a common and civil law system working together. It's also bilingual, so we have official English and French languages, and those interact with each other. And how do we make the laws apply to everyone equally? And how are those interpreted by people or speakers of different languages? And we also have a number of indigenous languages that, primarily are not recognized a lot, but there are like developments in terms of how they are being recognized. In Nunavut, for example, we have an official language there. And then looking at legal discourse, basically what I mean by this is when language is used in legal interactions. And typically this includes a legal actor interacting with a civilian. So this would include things like courtrooms, so like courtroom questioning, police interviews, 911 calls, crisis negotiations, traffic stops. And I think more interesting, another layer on top of this, is to think about when we use interpreters in these types of legal contexts. So this is often studied, and I think the primary goal for a lot of this this research that comes out of the more legal discourse aspect is obviously descriptive in the sense, but there's also a motivation for social justice behind it too. So how can we maybe better the legal system or increase access to the legal system for the diverse population of, Canada specifically, but around the world? So it can often come off as more critical, specifically of like courtrooms and police agencies. But I think it's important not to think of it being like criticizing any individual or something, but rather we are identifying patterns that might serve as limitations to people, and there can have very significant effects of that, which I'll hope to show in a little bit some of those effects. So people would be interested if we're looking at legal discourse in terms of things like different power dynamics. Obviously, in all these kind of interactions that I've noted here, we have a legal actor who has a position of authority over the civilian that they're interacting with. Turn-taking sequences, obviously coming out of things like methodologies, like conversation analysis, and looking at ideology. So this is another thing when we're thinking about, are we being critical of a person? And, you know, should an individual police officer feel like we are criticizing their practices? I think the bigger issue here that we are talking about are ideologies and how people understand the way the world works, and maybe more specifically how language ideologies work. And people's perspectives, and you know, how can we as linguists add something to this conversation and maybe ultimately help people. Also interesting, I think interesting are language crimes. So language crimes are basically crimes that require language. So some of these will be classified as an illicit speech act. So they require a speech act that is deemed to be criminal. So this would include things like perjury, defamation, bribery, solicitation, conspiracy, threats, and then also things I would consider language crimes or related to language crimes would be like consent and plagiarism too. So this is interesting when you think about like what speech acts would perform these, and I think linguists can, you know, are in an interesting position to help define what would be required in, for example, you know, solicitation. You have to have a request or a command. For conspiracy, there has to be an agreement, right? What is a threat, and how does a linguistic definition of a threat, or like the pragmatic applications of that, differ or compare to the legal definition of a threat? And I think they can work together, and kind of leads into the next thing I want to talk about, language evidence, and how we can help, once we kind of have a better understanding of how these work in language, then how can we define or help identify those when they're happening in actual language evidence stuff. So language evidence is basically language that becomes evidence in the legal system. So this includes criminal cases, civil cases, investigative matters, and it includes all modes of communication. So written, spoken, signed, and this is typically what people would consider forensic linguistics, in the sense that there's a linguist serving as an expert of some sort, doing an actual analysis, that you write a report, and whether that's for a law enforcement agency, a legal team, a private investigator, a risk management firm, something like that, where you're hired as a consultant to do the analysis. I think the ultimate goal for expert witnesses should be to actually just explain language use to laypersons, right? So people might think they have an understanding about how language works, but I think there's some limitations to that, right? So if you have a lawyer or a judge, someone who who just thinks like I speak English, well, there's a difference between speaking a language and understanding kind of the mechanics that go behind it, and some theories and ways we can analyze it, the methodologies from linguistics that we can apply to this, which can, I think, be very beneficial. An analogy I like to make is like a person driving a car knows how to drive a car, but they don't know what's going on under the hood, right? And that's the kind of where linguists can play an important role in helping explain language evidence to people. So some examples of when language becomes evidence in the legal system, and I think that some research questions or some applications that linguists can help answer or provide some sort of expertise towards include things like trademarks, for example. So in trademarks, there's kind of two applications that I view linguists playing a role. So one of those would be in establishing distinctiveness. So trademarks have different levels of what makes something protectable or not. So there's different levels of distinction. So it would be like a fanciful mark, which is a mark that is a word that's created for a brand or something. Under that, you have like suggestive, arbitrary, and those are all protected marks. So you can have a mark that, if it falls into that distinctiveness level, that can be protected. Anything that would be descriptive or generic can't typically be protected as a trademark. So by looking at, I mean, most of the work that linguists are doing in this area is coming out of corpus analysis and looking at how people are actually using language, and when a word, like what is that process of creating a new word, and how do people use a word? What do they use a word to refer to? And a word can lose its distinctiveness mark. It can go through a process of genericide if the brand, the mark, becomes the generic word for the term. So we see that happening in, for example, like escalator. Escalator was a brand, and now it's just the generic term for an escalator. Same thing with trampoline. So by looking at how people actually use language, we can investigate these sort of things and how people are referring to things. typically, if it was a protected mark, we would expect to find the trademark acting as like a modifier for the generic brand, right? So you'd have like Nike shoes, something like that, where you modify shoes, the generic term. I think, I mean, it doesn't, I think a clear example of something that might be going a process of genericide would be something like the word Google, right? Google, you can use it as a verb, right? To Google, and we use it all the time. We see people using it all the time, and that's an indication that it is becoming the generic term for, I don't know, searching the web or something. Infringement, though, is a little bit different. I mean, these can relate to each other in a sense, but typically with infringement cases, a court is interested in the confusability of a mark. So a mark that might be similar to another mark within the same domain of the product, so a same consumer type. And so they would be interested in sight, sound, and meaning. And interestingly, well, maybe not interestingly, those correlate to some linguistic domains. So sight, we could be looking at orthographic things. Sound, we'd be looking at obviously phonetic things, and meaning, we'd be looking at semantic things, right? Contracts are interesting too. I talked before about legal language and then the relationship that has with plain language. So I think it's interesting to think about who contracts are written for. And there's been a push in the legal, in the legal system, where a person has to understand what they're signing to agree to it, right? So if you have a consumer contract written for someone, it has to be in a language they understand. So if we can identify parts of a contract or the language used in a contract that can be confusing, technical language, long, complex sentences, stuff like that, we can help make these contracts more understandable for people. So there's a large plain language movement going on in terms, and there's different jurisdictions that have legislation that say, your consumer contracts have to be written in plain language. So I think that's a great opportunity for linguists to get involved, and we can identify why something can be confusing and what language might be more accessible to the wider population that the audience of the contract is for. Same thing with jury instructions. There's a lot going on with that too. Ambiguity. So contracts can be ambiguous. I think that's a part of that is an effect of the legal language that's used sometimes because it can be confusing, right? So I think by the time a linguist get involved, it's pretty clear that there is some ambiguity going on. People have different opinions of what a contract might say, but a linguist can help explain why is something ambiguous, right? Is there a structural, something syntactically going on that makes this ambiguous? Is there a lexical item that might be ambiguous? Maybe there's a morphological aspect that makes it ambiguous. Legal interpretation. So this is when the courts are faced with interpreting the law. So there might be a word in a law that people are debating the meaning over. And again, corpus linguistics have been the primary kind of source of where this is. Seeing some significant ground in applying linguistics to answering these questions and looking at, how do other laws use this? So we can build a corpus of, other laws, where we can look at the common meaning of something. That's typically one way to approach what a word might mean, what the common meaning is, however you want to define that. So we could look at maybe the more general use of a term in context. An example of this case, Larry Solon and Tammy Gales have a paper talking about the term discharge, right? So does discharge, if a person was fired off, I can't remember what the case was, like 9 shots from a gun, do they get charged with one count of discharge? Is that act discharging a weapon, or is each individual shot a discharge? So that could be a linguistic question, right? We could look at how people use discharge and what they use it to refer to. Authorship cases, this is what a lot of people think about when they think about forensic linguistics. So this would be when you have some sort of an anonymous document. That might be something like a threatening communication, maybe a ransom note, a potential fake suicide note, extortion letters, corporate espionage thing, defamatory comments on online posts, where there's a question document, the authorship, who wrote it, is up for debate. And typically they have some suspect authors. So they have people in mind who that might be. So we would collect those known writing samples of those people and then conduct an analysis looking at linguistic features that might co-occur or don't co-occur in these different documents. So there's different methodologies to this. I don't want to go too much into that today. I'll just say there's stylistic approaches, stylometric approaches, and more computational approaches to it. Different people have different perspectives. I think the answer might fall somewhere in the middle for all of these, but I do think linguists are in an opportunity to play a role in doing these types of analyses because we understand language variation, right? We know that language varies, and we know that it varies at all levels of language. And it also varies in relation to different social factors, right? So that leads into kind of the next 2 points in regards to speaker comparison and profiling. Because we know that variation often correlates to different social factors, aspects of a person's identity. It might be a regional variation, it might be an age-graded thing, it might be arguably a gender thing, maybe an occupational thing, an education thing. We know that people use different language based on different life experiences and different socialization. So that results in different language use. So by looking at the language that's used in an anonymous document or something, we can help either develop a profile and maybe narrow their suspect pool, or in speaker comparison instances, look at, that deals with more phonetic aspects of the vocal, the whatever verbal spoken language evidence you're dealing with. Forensic transcription, that involves if you have some sort of undercover recording of some sort, and there might be a dispute over what a word was or what was said. So often when we have undercover recordings, they are not the best quality, and different people might have different interpretations of this. And I think it's important that we think about the role linguists can play in helping these transcripts, because linguists understand things like priming and how that can affect what's interpreted, and also things like just the context of being, if an officer is doing the transcription, they're so involved with the case, they might have the schematic understanding of what they think should be there and what they understand to be there. So by looking at it from a more scientific level, and this might be looking at different formants and like a spectrogram, something like that, or just not being involved with the case, being a third party in general, puts you in a specific position to help provide more accurate transcriptions, because a single case can rest on a whole word. And if you're providing a transcript like that, it can have a very big impact in what you give to the jury, for example, for what they understand or what crime a person is even charged with to begin with. And then confessions. Confessions are quite interesting because there's a lot going on in here. I'm going to talk about in just a minute different aspects of police discourse, but I also want to touch on some cases where confessions, there's a question about authorship in terms of written confessions. So I'm looking at different things here, police discourse in general, and often what might lead to some false confessions, or at least different understandings of investigative interviewing techniques and the language involved with that. But then also sometimes we get a written statement of something where the authorship, so a suspect says, I didn't write this, I just, my signature's at the bottom, but they typed it up, they wrote it, I didn't say this, something like that. So it becomes a question then of an authorship case in some cases, which I think my dissertation work is looking at police reports and the language that police officers use. So I think having an understanding of a police register can be quite important in that, just like I talked about a legal register. So we see these correlations in terms of understanding how different people in different aspects of their job, the legal, the law in general, policing in general, might have really important implications for language evidence afterwards. Okay, I want to talk, because I know this is an applied linguistics program at Brock, I want to talk about some specific applications that might be more geared to people in this program of applied linguistics. And I consider all of this forensic linguistics stuff to be applied in some sense, but I think people with expertise in a more narrow definition of applied linguistics might be more suitably aimed for questions like, would a person understand the speech event and the language used in it? Should they have used an interpreter? Was the interpreter using an appropriate language or a specific language variety? Did the interpreter help? Could there have been a misunderstanding happening in this communication? Also, with regards to language assessment and evaluation. So if we think about something like comprehension of legal language, we know through research that police cautions are very difficult to understand. And if you include then some elements of maybe a person who is an English second language learner, or a person who speaks a different variety other than like a standard variety of English, how lawyers communicate with their clients. Do they understand what the lawyer is offering them if they're telling them about a plea deal, or what the process is, what they might be agreeing to? Courtroom proceedings, do they understand what's going on in the legal process, especially if they're testifying, right? And this can be grounds for a potential claim for ineffective assistance of counsel if you find that a person should have probably had an interpreter here in the courtroom, but they didn't have one, right? And obviously, if they didn't have one in a police interview, they probably didn't understand what they were agreeing to if they waived their rights. Also, obviously, I think intercultural communications in the legal system. So obviously this would involve like language variation things, but also just cultural aspects involved with the legal system. And I think that's very interesting in Canada, where we have this very diverse population in terms of different cultures coming together and different languages coming together, and how they interact with the legal system, and obviously ways that we can try to improve access for some people. There's also a number of communicative limitations. So people in speech sciences, communication disorders might be interested in looking at how different limitations affect people who don't speak a dominant variety, a spoken language like that, right? So for example, Vernon and Miller talk more specifically about deaf people interacting with the legal system. So, I mean, if you think about, there's plenty of examples of deaf people not hearing a police officer's command and then being like violently taken down or tased or something just because they didn't hear the command. And then they get arrested and now their hands are behind their back and now they lose their main mode of communication. And then the whole police interview, criminal proceedings or whatever's going on at the trial, we know that people who use interpreters in these settings are often at a disadvantage of some sort, and it takes a lot more time. And then when a person goes to prison, if they're deaf, they can't hear often officers' commands there, and even the buzzers and stuff that tell them when to eat or when to do certain things. So. Also, language analysis and the determination of origin. So this is specifically more regarding refugee and asylum cases where there can be a question about where a person is claiming they're actually from. And there's a debate in the field about who is more appropriate to be doing these types of analyses. Is it like a native speaker of a language, or is it a linguist who can understand the more nuanced aspects, grammatical, phonological aspects of it? And I think importantly, though, is that a linguist has a better understanding about the idea of socialization, and that there's not a direct correlation between geographical boundaries and a person's language use, especially if they move throughout their life. Okay, so I want to talk about two studies that I've done that would be like in the domain of police discourse, which would fall under the aspect of legal discourse that I talked about. And I want to, by the time I get to the end of these, I want to hope that they play or demonstrate that they might play a role when language can become language evidence, to really show that these aspects that I've identified within forensic linguistics should be working together. So the first thing I'm going to talk about is this discourse strategy that I've noticed in police interviews, in male officer, male suspect interviews, when officers basically say you need to be a man. And then I want to also talk about when officers can compare police cautions to TV. So just so we're on the same page of how I'm approaching being a man in police interviews, I'm looking at this, obviously, the relationship between language and gender here, and viewing language as a resource for explicitly or implicitly marking, judging, constructing, and invoking performative aspects of gender. And then that, by looking at it this way, it allows us to examine how gender is constructed in discourse and how speakers position themselves in relation to contextual gendered identities. If we think about the occupation of policing, it's socially constructed as traditionally masculine, and it's obviously male-dominated, blue-collar, commonly seen as necessitating physical strength, violence, aggression, courage, and solidarity. So this is how we perceive policing, obviously, as a more hegemonic masculine position in society. But then when we look at the police interview itself, it's interesting how the suspect gets positioned. So Ainsworth points out that the physical setting of the circumstances of custodial interrogation magnify the helplessness of the arrested person. The suspect is often restrained, isolated in a room, confronted by one or more police officers, and restricted in abilities to eat, sleep, smoke, and go to the bathroom. And then the Miranda v. Arizona case, Supreme Court noted that it is obvious that such an interrogation environment is created for no purpose other than to subjugate the individual to the will of his examiner. This atmosphere carries its own badge of intimidation. To be sure, this is not physical intimidation, but it is equally destructive of human dignity. So my point here is that the police interview is essentially emasculating for a male identifying person in the context of the police interview. Where resources to invoke or index their masculinity, such as, performing things like physical strength, violence, aggression, can't be performed because those resources are not available to them in this context. And then also from a conversational perspective, we see control being essentially taken away from suspects, and that officers are able to ask the questions, control the topics, the tempo, the tone, and the length of the interview. So if we correlate control with masculinity, we see again the suspect in this, again, emasculated position. So these are examples from actual police interviews with male officers and male suspects. So he manned up and had some remorse. Look at me in the eye like a man. You at least be a man, at least tell me, what, Detective Gibson, I screwed up. You stood up as a man and said, I did this. Time to man up, George, tell me what happened. And this is your last chance to just kind of let us know, to be honest, to man up and tell us exactly what you did and start making it right. You need to start being a man. You need to man up and start talking to us. You've got to be a man and admit it. You've got to be a man. You've got to stand up. A man admits his mistakes. A real man would tell the truth. A real man would tell the truth. Talk to a real man. You ain't man enough to fucking take responsibility for it. So basically we see various behaviors such as telling an officer what happened, telling the truth, taking responsibility, having remorse, and making eye contact as behaviors that would index this contextually constructed masculinity. And I think importantly here is that a lot of these behaviors result in incriminating statements. So it's interesting from a language and gender perspective because here we're explicitly marking the performative aspect of identity, but these appeals to a suspect's masculinity positions their masculinity as an important aspect of their identity. And this suggests that officers anticipate that there's an expectation to conform to gendered expectations. So this threat to masculinity of not being a man is therefore expected to make someone confess to criminal accusations. So to me, it positions the suspect in this, what I call like a gendered dilemma, where they can either be a man and provide incriminating statements, or they can be less than a man and then deal with the emotional and social consequences. And we don't have to think too hard about some of those social and emotional consequences of people who don't conform to gendered expectations in our society. Okay, and then I want to talk about this study briefly, where I compared cautions to TV. Well, I didn't compare cautions. Well, I guess I did. But when officers compare cautions to TV. So just if you're not familiar, this is obviously from the United States, looking at the Miranda warning. So a result of the Miranda v. Arizona 1966 Supreme Court decision that says the person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that Anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation, and that, if he is indigent, a lawyer will be appointed to represent him. So there's some known issues, but there's no actual wording that's required. Basically, an officer just has to inform them of their rights, but no specific wording. So there's a lot of variation across all the jurisdictions in the United States. But a main issue that comes up a lot of the times is comprehension issues. Some of the ways that these rights end up being written, I'll show you an example in a minute, aren't very comprehensible to a lot of people, never mind people who might be, for example, second language learners or who speak a variety of English that's not, a more dominant variety. But I find one aspect of this more interesting, looking at what Leo and White call officer mitigation, and a way that they describe officers de-emphasizing the significance of the Miranda warnings. And one way that they identify is that officers often refer to their dissemination in popular culture. So this is an example of what a typical Miranda warning would look like. This is what's used in a lot of the language and law literature. So you have this kind of 4 main rights, I guess, and then a continuation clause where you can invoke these rights at any time, and then an understanding component, and then finally an opportunity to waive or invoke the rights. So these are examples from, again, actual police interviews where the officers make some sort of comparison to the Miranda warnings on TV. So it's kind of like TV. This is just like on TV. Okay, basically, and you've heard the Miranda warnings on cops and TV and stuff. It's just like TV. I don't know if you've heard about it, if you've seen it on TV. I'm sure you've watched television with the cop shows, right? And you hear them say their rights. And so you can probably recite this better than I can. You watch TV, you know the drill. I'm sure you've seen this on TV 1,000 times. So you've probably heard or seen this on TV before. So Leo and White describe this as a discursive strategy to mitigate the importance of their rights, and they claim that by referring to the dissemination of Miranda warnings in American popular culture, interrogators seek to trivialize the warning's legal significance. Their hope is that the suspect will not come to see the Miranda warnings and waiver requirements as a crucial transition point in the questioning, or as an opportunity to terminate the interrogation, but as equivalent to other standard bureaucratic forms that one signs without reading or giving much consent. So I don't agree with this completely. I like to think that officers have good intentions and that by maybe making this comparison to their dissemination on TV, that a suspect might understand the situation a little bit more. But as we'll see, I think that this can be problematic. So one thing to point out, though, is that in 2000, the Supreme Court had an opportunity to overturn Miranda. So this is the Dickerson decision, where basically they say that Miranda has become embedded in routine police practice to the point where the warnings have become part of our national culture. So interestingly here, their judicial decision is based on how people in society are using the Miranda warnings and kind of their dissemination in their national culture. But some important things to think about if we assume that people might know the Miranda warnings from TV, I think it's going to be problematic because, and people do make this assumption, so obviously officers do in those examples that I showed, but also one study found that 85% of police chiefs thinks that most offenders already know their rights. But then if we actually look at what people think they know of their rights, one study found that 1/3 of participants described themselves as truly uninformed, having 0 to 20% knowledge of their Miranda rights. So we also have to think about that if we presuppose that knowledge is coming from TV, we have to really, I think that not everyone in the United States has seen their Miranda warnings on TV. And I think this is especially true with people who might live below the poverty line and not have access to cable network television, and people who don't watch TV in English. So I'm specifically thinking about immigrant families, which I think is problematic when we think about who is more overrepresented in the legal system. They would be probably those minority immigrant families and people living below the poverty line. There's also an assumption here that suspects understand their rights, and I think we have to make a clear distinction between knowing your rights and understanding your rights. So one study found that only 21% of juvenile and 42% of adult offenders fully understood their rights. Another study found that only 64% of college undergraduates almost 64% of college undergraduates displayed 2 or more fundamental errors in their Miranda understanding. And then a more recent study found that only 3.4% of L2 speakers enrolled in advanced ESL courses are able to demonstrate even a marginal understanding of Miranda warnings. So this is interesting because we see things like age, education, and English language abilities all kind of affecting who understands their rights and if people can understand their rights. So I was obviously interested then, if officers are making this comparison to TV, what's actually happening on TV? So I had a bunch of research questions. I'm not going to go through everything. I'm just kind of want to get to the point here. But basically, I looked at Law and Order on TV. I looked at, if you don't know what Law and Order is, it's a police procedural drama. It's been on for a long time. And I looked at seasons 1, seasons 10, and seasons 20 to kind of get an overview of what's happening. So I looked at 66 episodes. And I'm not going to go through all these numbers. The main points really that I want to point out is that, I'll come back to this, is that the vast majority of the time, 91% of the time, there's no Mirandizing process on TV. So suspect could get arrested and then there's just an interview and they're interviewed. If there is a Mirandizing process on TV, it is incomplete. It's an incomplete Miranda warning. So what I mean by that is that, if I go back here, we never get this full component. I was specifically looking for these 5 components to be a complete version. We never get a version that includes this clause here, this number 5 point. But if we do get anything, it's going to be you have the right to remain silent. So I identified that as kind of this minimum component. But yeah, we never get a full version. And then when we look at how their rights are invocations for their rights, again, I'm not going to go through all these numbers today, but basically we find that few suspects explicitly attempt to invoke their Miranda. So only 11% of the time do we see suspects actually saying, get me a lawyer or something like that, or trying to get a lawyer. And of those who actually attempt to invoke Miranda, there's a 50-50 chance of it being successful or not. So a successful invocation would be, the questioning stops or that an attorney is obtained. Often we find, though, that attorneys just appear without requests from suspects. So if you're sitting in a police interview room and magically another lawyer appears for you. So I think this is an indication that it's not like TV in this sense, that Miranda is not being read most of the time, and if it is being read, it's being read only, a partial amount of the time, or only a fraction of the actual Miranda is being read. And then when it comes to the invoking your Miranda, people aren't doing it on TV, so we're not really educating people, or there shouldn't be a reliance on how people actually successfully do this on TV. So Ainsworth points out a number of ways that you can essentially go wrong in trying to invoke your rights in real life. So these are based on real cases and actual Supreme Court or whatever different court decisions. So she points out that only clear, unambiguous, and unequivocal invocations are legally affected, and unless the right to counsel is invoked using a bald and completely unmined imperative, such as give me a lawyer or I want a lawyer, then the arrestee's attempt to exercise this constitutional right is unlikely to be respected either by the police or by reviewing courts. So therefore, as a practical matter, the rights are very easy to waive and nearly impossible to invoke. So Ainsworth points out ways that you can essentially go wrong in trying to invoke your rights in real life that won't result, or that are unlikely to result in actually invoking your rights. So if you use something like hedging, such as I think I want a lawyer, you're not likely to be successful. And I found the same thing happening on TV. And also if you're using indirectness, so if you use something like an interrogative form, could I call my lawyer instead of an imperative, call my lawyer, you're also not likely to be successful in trying to invoke your rights. And I found the same thing on TV. And then if you combine a refusal to answer and a request, so I'm not going to participate any further until I speak with my lawyer, you're also not likely to be successful. And I found the same thing on TV. So Ainsworth points to a number of linguistic ideologies that are underlying these of the police officers' decisions in this, and then ultimately the court's decisions in finding that these are not actual invocations of Miranda. I'm not going to go through them, but my assumption then is that these are being reinforced on TV, and that they are guided by these same linguistic ideologies. By doing this, I view this as problematic, and I realize I'm somewhat contradictory here when I'm saying it's not like on TV in terms of how Miranda is invoked or how Miranda is read, if it's read at all, but it is like TV in the sense that if you use different aspects of trying to invoke your rights, such as hedging, indirectness, or combining a refusal to answer with a request, that is like TV. But I view this as problematic, especially when we think about the Davis decision that I talked about that is relying on the popular dissemination and the way that Miranda is viewed in society. So you end up with this circular type thing where the law is relying on essentially popular culture, and popular culture is hopefully relying on the law. So we never get to fix this, these ideologies that get reinforced going back and forth, because it is problematic to assume that language is always going to be objective and transparent when we know that that's not how people use language, especially not how people use language in trying to demand something from an authority figure in a police interview. So I think this brings up an interesting discussion about the relationship between TV and a layperson's perceptions and their interactions with the law. And I think the reality that sometimes legal dramas influence people's perceptions of the legal system. And I think this is, I don't know, there might be a shift in this. I think there's a lot of more true crime documentaries and like miniseries, docuseries stuff coming out highlighting different civil rights violations. But I do think it's problematic if police officers are relying on and encouraging suspects to rely on these perceptions in the actual interview when they're introducing Miranda. Yeah. Okay, so I want to wrap up basically by talking about forensic linguistics in Canada and kind of where we're at, and then hopefully I'll provide some suggestions of where the field, some things we can maybe do. So I want to point out that this is a relatively developed field in other countries. So like in Germany, in the UK, even in the US a little bit, there are institutes, there's degree programs, there's conferences, and there's job opportunities for people studying forensic linguistics. So it's treated as a field that people can study, and there's an awareness of it to some extent as well. In Canada, there's no clear resources for students or researchers or for legal practitioners, despite it being an increasingly popular field. So I have people emailing me all the time or reaching out on social media and stuff, asking me and wanting to meet with me about how do we get into this. And I don't have a clear answer for them because there isn't a resource in Canada for people to kind of find out more about the field or the people involved with the field. I think there's a lack of research on Canadian data, which is a little bit disappointing because, as I talked about before, the context of Canada, even when we think about the bilingual aspect of it happening there, it's really interesting from a linguistic perspective. We have a lot of researchers in Canada, but a lot of time they're working on American data. Myself, for example, those two studies I talked about come out of are based on American data. So I'll talk about my suggestions that I'd like to see a shift where people start focusing on Canadian data. There's also a number of Canadian researchers elsewhere, and I don't think that's that's just an aspect of academia or where they kind of end up at what institution. But the effect of that, though, is they start basing their research more on the more local data. So it's not coming back to Canada. And there's a lack of interdisciplinary networks in research. So if I go to some of my proposals and things I'd like to see, I think that students should be encouraged to explore the field. And this doesn't have to be in a specific forensic linguistics class by any means, but a course on discourse analysis or a course on sociolinguistics. You can encourage students to look into some of these aspects because I do think there are, I think it's interesting. I think people are here listening to me, so people find it interesting and they're interested in it. But I think there can also be like very significant actual applied like there's applications of this to the real world, which I think it's a motivating factor for me to get involved, and I'm assuming that it's true for other people. I'd also encourage research on Canadian data. Like I said, Canada is a rich source of very interesting unexplored data. We have a very interesting social context in terms of our population, our history, our legal system. I think it'd be interesting to replicate some existing research with Canadian data. So obviously stuff like from the United States, or more specifically, I think stuff from Australia can be directly applied to the Canadian context, but I think someone needs to replicate that. It's I'm specifically with like the Indigenous populations. There's a lot of interesting overlap happening there. What I'd really like to see happen is a local network to be built where we can bring together researchers from different fields doing very similar research. So people from linguistics, sociology, criminology, policing, psychology, socio-legal studies, legal scholars, stuff like this. We're all interested in a lot of the same stuff, and we're all a lot of the time working on the same data, but we're taking different methodological approaches. And I think that linguists can play a really interesting role if we start working with some of these other researchers. Also involving practitioners. So not only working with law enforcement officers and agencies in terms of consulting and offering linguistic expertise to them, but also educating lawyers and judges and officers on what role, like what can a linguist do? Like how does language play a role here? How can we improve access to them? And I think this would also help open up opportunities to data access as well. And then, like I started out talking about today, I think that we need to start crossing some of these terminology boundaries. So instead of viewing forensic linguistics as one thing, legal linguistics as one thing, jury linguistics as one thing, language and law as all separate things, I think they all work together, because I'd like to think that those research, those studies that I talked about, can have important implications when a piece of language evidence, a confession, comes to light, and a linguist can play a role in that analysis. And then ultimately, I think something that we should think about in the future, which I know there's some talks in the works of, so keep your eye out for stuff like this, that there will be a symposium or a conference of some sort where we can bring all these people together and share all of our different insights from maybe different perspectives. So that's all I have. Thanks for coming and listening, and yeah, I'm happy to have any questions.